leading us through the conversation about EU data protection. Great. And Jim will be leading us. Rebecca, will you be also talking about the next free speech and academic freedom stuff, or is that all Jim?
That's all Jim.
Okay. And Jim Newberry's up there.
Yeah,
he's with
sure.
Crypto. He's in Lexington.
Terrific.
Rebecca, are you somewhere in Ohio?
No, I'm in Louisville, Kentucky.
Oh, okay.
Mm-hmm.
And that's why you're able to say Louisville correctly.
Yes, I think so. When I was a little girl, it was Louisville, so it has morphed over time.
Become more southern.
Mm.
Or something.
Sounds about right.
I think this is our group for the time being. I think our director of international studies is going to join us shortly. He also is chiefly interested in the EU data protection issues, but he may stick around for the others too. I don't. He's just back from Myanmar and Thailand and other places in Southeast Asia.
Mm-hmm.
Mm.
We will be delighted to have others as they have the opportunity to join us.
Okay. What did you cover in your first webinar?
Preparing for and dealing with campus unrest. It was back in September, sort of on the heels of all the activity at UVA.
Sure.
And we had a pretty good turnout for that, as you might imagine. Incidentally, Jamie, the ACS folks are putting these webinars, seminars on their website. So if you want to go back and look at it, you can go to the ACS website and locate it.
Okay, I would like to see that.
Well, we have some folks that are beginning to join us from throughout the South here, so we'll start in just about another minute.
All right.
My clock indicates it is now 12:30, so we'll go ahead and get our video conference underway. I'm Jim Newberry, and I want to welcome everybody to the second Associated Colleges of the South Legal Topics Seminar. We are delighted to have the opportunity to be working with ACS, and this is part of our overall relationship with the Associated Colleges of the South. Every quarter or so, we'll be doing one of these video conferences on topics that we hope will be of interest to a number of the member institutions and their staff. So delighted to have you with us today. Let me take this opportunity to introduce one of my colleagues, Rebecca Bates-Mano, who's in our Louisville office today. Rebecca is going to be giving the first part of the seminar, where she'll be talking about the EU's General Data Protection Regulation. And then I'll finish up on a discussion of some free speech and academic freedom issues following that. Let me tell you just a bit about our relationship with the Associated Colleges of the South. Some of you may be familiar with this, others may not. Our firm began a relationship with the ACS back in the summer. As a part of that relationship, we do some educational programming, including this seminar and monthly newsletters on hot topics of legal interest to members. And we welcome your suggestion about what topics we will be addressing. Today's two topics are ones that were given to us by Jennifer Kirkland at Washington and Lee, who recommended we talk about the EU's data protection regulation. And then Jamie Leahy at Center, who recommended that we talk about the free speech and academic freedom issues. So Jamie and Jennifer, thank you very much for your contributions. And let me just say, For those of you who have other topics that you think might be of broad interest to your fellow ACS members, don't hesitate to drop me an email or give me a call with those topics, and we'll try to work them into the process in the very near future. Let me just briefly give you an overview of what we're going to be doing today. As I said a moment ago, Rebecca is going to lead off talking about the EU General Data Protection Regulation. We'll go for roughly half hour, perhaps a little longer about that. Then we'll have a Q&A session where those of you who have follow-up questions on Greg can raise those questions at that time while it's sort of fresh on everybody's mind. And then starting at roughly 1:15, and there's no magic times, but at about 1:15, I'll start the presentation on free speech and academic freedom issues. That too will go for about a half hour, and we'll leave some time at the end for questions and answers. So without further ado, Rebecca, let me turn the floor over to you, and you can tell everybody just a little bit about your background and then get into the presentation as you wish.
Can I interject for a moment before you get started, Rebecca?
Sure.
Somebody on the call is doing a lot of typing or clicking or something. I'm hearing a lot of that noise coming through.
So yes, and if you would, please mute your microphone if you're not in the process of asking a question or engaging in the conversation. You can find the mute icon if you hover over the Zoom screen. There's a microphone on the left side. If you click on that, that should effectively mute your microphone.
Okay,
thanks.
Thank you.
Okay, Rebecca.
Thank you all. I am Rebecca Bates-Mano. I do work in the firm's Louisville office. I've been working in compliance and in discovery for several years now. And as we add things to think about in terms of compliance, I just continue to roll them into what I know about the overall field of information governance, because I think really that's where all of this falls. And years ago, we used to call it records retention. And as issues become more and more important with the electronic nature of almost every piece of information that we have now, we've rolled more and more responsibilities into that particular discipline. But I think this may be one of the things we need to think about when we're starting to put together or reviewing our information governance plans. And that's the European Union's General Data Protection Regulation. It's called the GDPR for short. It is a protection regulation designed for EU residents. And it's Regulation EU 2016-679, if you'd like the citation for it. It becomes effective on May of 25th of 2018, so it's coming quickly. And it's going to replace the EU Data Protection Directive of 1998. And that one is where I started having an interest in it, because when you do discovery like I do, a lot of times you'll have different companies that have a parent or a subsidiary that's across the pond, as we like to say. And so we have to get familiar with what those issues are for transferring data. And I think that's one of the big ones that they concentrate on when they're looking at the protections for their EU residents. So the General Data Protection Regulation was put in place by the European Parliament, the Council of the European Union, the European Commission, and it's intended to strengthen the data protection, as I said, for all individuals within the European Union. But the new regulation has the same core concepts and some of the same terminologies that the old protection directive had. So I wanted to take a look at some of those core concepts. And that's this slide here. One core concept to keep in mind is that the GDPR, like that data protection directive before it, is designed to provide protections for personal data. And the personal data protection is based on protecting the rights and freedoms of individuals who are in the EU. And that is part of the Charter of Fundamental Rights of the EU. So for the EU, it appears that the GDPR is going to be a reflection of the tradition of European focus on human rights. And it's an important concept for us to think about in the United States, because I think Americans have traditionally accepted that there's a trade-off between privacy and personal information for the sake of commerce and for the sake of ease of transaction of business. So it's a bit of a paradigm shift for us, really. One of the other core concepts that we think about when we're thinking about the GDPR is, what is it protecting? And it's protecting personal data. And I think that's definitely a core concept. It's a little bit more expansive than it was in the directive. It is the usual things that come to mind that would identify an individual, like your name, your address, your birth date. But it can also be something as simple as a photo or an email address. Medical information, obviously, especially genetic information. A post on a social networking site, that's an interesting new twist. And hobbies and habits, and any information that's linked to your individual behavior. Also location data or an IP address. So essentially anything that can identify an individual, separate them from a group, is going to be personal data under that concept. And the idea that hobbies and behavior would be something that's protected, again, plays into the rights and the freedoms of the individuals in the Charter of Fundamental Rights, because in addition to the right to protection for your personal data, you have a right to privacy and happiness, basically, in your family life. So I think where that might come into play for the universities and higher education institutions is that if you want to mine your data for trends or marketing suggestions, or do some concept analysis using algorithms, and there's personal data of an EU resident in there, we're going to have to really think carefully about that and how we get that done without trampling the rights and freedoms of those individuals. And so maybe not for the colleges and the universities, but sometimes for the colleges and the universities, people who analyze big data, as it's called out there now, I think they're really going to have to think about this new regulation. So we can go on to the next slide. I appreciate you driving, Jim. I'm sorry.
Glad to do it.
This one is about the terminology that was within the directive and is still within the GDPR. And the things that you think about, how they label the different actors. Data subject is what it sounds like. It is the person whose personal data is at issue. A data processor, that is a person who holds or obtains data or does any operation on it. And the data processor is most likely these days to maybe be your vendor, like your cloud provider, or perhaps even a data controller who has their own internal storage for and processes on information. Then a data controller has the personal data of a data subject and determines how and why the data is used. And they'll work in conjunction with their data processor, or they could operate in both capacities. And that wouldn't be unusual, for example, for a university who's doing some kind of analysis on genetic information or something like that. So we can go on to the next slide. We've talked a little bit about our core concepts and some of the terminology. And I want to look at the changes that we've seen from the directive to the GDPR. And one of the biggest ones is the scope of the application. So when I look at the terms of the GDPR, it sounds like it's going to be peculiar to the EU and also perhaps to Britain, because it will go into effect before Brexit takes place. But I think one of the most important changes that sets the GDPR apart from the data protection directive is the scope of the territory that it intends to cover. Certainly, any EU business, so if you're in an EU member state or have an organization that is part of you that's in an EU member state, then if you control or process the personal data of a data subject that's a resident of the EU, you're going to potentially be subject to the GDPR. But now a non-EU controller or processor, perhaps like maybe your college or your university, would be subject to the GDPR if you offer goods or services to EU residents or monitor the behavior of EU residents. So if your university is offering goods or services to an EU resident or doing some big data projects on the personal data of an EU resident, your organization may be subject to the GDPR. Certainly, if your university has a branch that is in a member state, it's pretty likely that the GDPR is going to apply to processing of personal data. So some of the folks in the legal community who've been looking at this issue as this is developed, because it's taken several years for Parliament to get their house in order and issue something, I think they are looking at it, these people who study the directive and the GDPR, and thinking that the intent of the EU may be to export their ideas about human rights and personal data to the globe. So they're taking a global view of privacy, and they want to globalize their view of human rights, and kind of given the fines that are out there and the scope of business these days and how easy it is for someone in an EU member state to click on a website and buy something. I mean, that may well be the effect over time. Then we can go on to the next slide. So one of the things that has, they did have rights, the data subjects, under the protective directive, but the data subject also has rights that have been expanded. The first one, I think, is the informed notice. And what that means is a data subject has a right to understand what their data is being used for. And I think it's a reaction, because we've talked about, with those of us who look at this, we've talked about how it seems that the GDPR is not a knee-jerk reaction, but definitely a response to changing technology and to changing ideas about how data can be transferred. And one of the things that I think they looked at was these long data privacy statements that sometimes we see on websites, and there'll be a click box at the end that's already checked, and it says you have to opt out of us using your personal data. So if you want to use our website, you have to let us use your data. And the GDPR is going to require controllers to change that a little bit, and they're going to have to be more cognizant of what they're doing with the data, and they're going to have to tell people what they're doing with their data. You also have to have access for your data subjects, rectification, so they have to be able to amend the data if it's to make sure it's correct. Erasure, that's a good one that I like, because it's the right to be forgotten. And sometimes I dream of going off the grid, which sounds crazy because I like my car and all that stuff. It's unlikely that I'm going to leave my iPad behind, but the idea is if you have the right to erase your data, you've got the right to be forgotten. What that means in practical effect, I think, for controllers and processors of EU data is that they're going to have to be able to find the data of a personal data subject, and they're also going to have to be able to erase it pretty easily. So you're going to have processes and procedures in place that would enable you to be able to fulfill that right for your data subjects. You have the right to object to processing. If you're an EU data subject, you have the right to object to profiling, which is the data mining. And that's normally an automatic action that takes place somewhere in the background. And so that's something that we have to think about, what are we going to do with our big data? I do think a lot of folks who have big pools of data are going to, in the future, be contacted by maybe marketing groups or other IT people who would like to be able to mine the data that you have. And that is something that would fall, I think, under this profiling. Have the right to restrict the processing during certain circumstances, and also have these last three are new. You have the right to restrict your processing, the right to unambiguous and explicit and affirmative consent to the processing. And that goes hand in hand, I think, with the idea of having your data subjects know how their information is going to be used, because they can't give explicit consent if they don't understand what you're doing with the data. So they'll have to be informed about the process, and they'll have to affirmatively consent. Again, they opt in, opt out. They'll have to opt in instead of opting out. And they'll have to be able to easily withdraw their consent. That's a portion of the explicit part of it. Then that last one is data portability, and I think this argues for good process and procedures for information governance as well, because the data subjects have the right to get their data and take it somewhere else. So there are some conditions on that requirement, but still, I think, thinking about finding the data in a hurry and getting it to the data subject is something we're really going to have to address. So all of the rights that are up there in the bullets are to be provided to the data subject free of charge, except under certain circumstances, and all the controllers and processors have to set a time within which they're going to respond to any request by the data subject. And I think the normal time period is 30 days. Move on to the next one. So we have the data controller obligations. I tried to focus on the ones that are just a little bit different from what we had with the directive. Data breach notification, the controller's got to report a breach of personal data to the appropriate supervisory authority, and that would be an EU figure, within their member state, within 72 hours of becoming aware of a breach, if there's a risk to those rights and freedoms that we talked about earlier, for a natural person. So if there's no risk, then they're arguing that there's no reporting obligation. And the GDPR notes that if a company has appropriate technical and organizational measures in place, then there may not be a risk, and so there wouldn't be a reason to report the breach. The appropriate technical and organizational measures are defined as those that ensure that the personal data is treated in accordance with the ideals and objectives of the data protection regulation. And we'll talk about some of those safeguards that might work in a minute. The accountability portion of it is that you want to be able to demonstrate compliance with the GDPR and the principles. So I think this is where a risk-benefit analysis really is going to come in handy, because you're going to want to look at the data that you have and see what is the risk to the rights and freedoms of any of the data subjects, and then make a decision about what kinds of protections you're going to put in place. And then using that analysis as a guide, you can find the appropriate technical and organizational measures that would suit the needs of the GDPR. For certain types of sensitive data, the controllers may need to do a formal risk assessment, which would be a data protection impact assessment, to meet with their accountability requirements. And those are normally going to be people who have really sensitive data, criminal information or health information. So that means that our controllers are going to have to know pretty well what's happening at the processor level to a data subject's information. And to do that, I think you've got to look at your vendor contracts and make sure that there are the appropriate languages in there, so that your data processors are sharing your obligations to your data subjects. Ensure that the safe transfer, I actually have it in my notes as preventing risky transfer, because I don't know that you can ever ensure that the transfer is going to be completely safe, but I think you can do, again, a risk assessment and figure out whether or not the person or the place that you're transferring data to meets the requirements of the EU. And that's not so much a problem, I think, for us on this side, but probably definitely something that people who are in the EU, excuse me, member states have to really think about, because they're going to have to be able to say that they've sent the data to a place that has protections that are at least as good as what they are employing. And the US, and the EU have hammered out an agreement that provides a means for US companies to self-certify that they're committed to the EU principles and that they're going to protect the personal data in an appropriate fashion. And that agreement is called the Privacy Shield. And it's going to be administered by the US Department of Commerce and enforced by the FTC and the Department of Transportation. So all of those controller obligations that are up there on that slide, I think they certainly argue for having a very good set of information governance policies and procedures in place that are going to include a thorough review of any of your service provider contracts. Because we'll look at the next slide, the data processors now have obligations as well. And they had them before under the Privacy Directive. But in fact, I think this is more targeted, because now the data processors share the responsibility in the respect that they can actually be sanctioned for their own actions. So it wouldn't be an action that went through the controller to the processor, it would be direct action against the processor. So under the GDPR, the processors and the controllers are sharing the responsibility for taking care of the data subjects' information. And as a result, I think we're going to see the processors paying more attention to their own MSAs, because in the past, when I've reviewed some of the vendor agreements for transactions, I look at them and think this is completely inadequate for almost anything. And I think you're going to see a step up in that respect. But the first processor obligation is, again, to process in accordance with the controller's instructions. And that goes to having really good language in the MSA to understand what the informed consent that the data subject gave for the processing applies to. So you don't want to go outside of what they've consented to. Using appropriate technical measures to ensure data security. Again, that is that same idea of doing a risk-benefit analysis, the benefit or the reason why you're doing the processing versus the risk to the personal data, and using appropriate technical measures, the safeguards, putting those in place again. And then for certain types of data, processors, they're going to have to appoint a data protection officer whose sole responsibility it is to watch after the policies and the procedures and make sure they're being maintained. And those are normally going to be your higher volume folks who are maybe even the data mining people that I think about when I think about big time processors. I'm going to go back just for a minute to the appropriate technicals to ensure data secure, technical measures to ensure data security. One of them is that pseudonymization. I love that word. I want to say that several times today, where they separate data points into different repositories so that an individual cannot be identified by one of the data points alone. And I think that's an interesting thing to think about, and we'll come back to that again. But another appropriate technical measure for a data processor might be to have a very good disaster recovery plan so that you always ensure that the data subject can get at their data because they have that right of access, and a data breach response plan to help your data controller be able to talk about what's happened to the data if something goes wrong. Okay, we'll go to the next slide. It's my little scout. You want to be prepared and get ready. I think the most important thing we can do to be prepared and get ready if we feel like we're going to fall under the GDPR for any reason is to do an assessment of your current information governance program and see what you already have in place. Maybe you're doing everything right. I think some of the questions you might want to ask would be, what IT systems do we have that have personal data in them? Who has access to that information? What types of protections are in place for that system? If we have vendor processes that are applying to personal data, do we have a good MSA, a good agreement that helps us understand what the processor is going to do? Will the contract with the processor enable you to be able to carry out your responsibilities? Can you get access in a timely manner? Can you identify specific information that can be erased or ported away? What kind of privacy policies do you have in place? That might be the easiest, lowest hanging fruit that you have, is just to look at your website and see, what does your privacy policy say about what you're going to do with personal data? Is it specific enough to allow somebody to have informed consent? Do you have a statement in there about, if you're from the EU, you assume responsibility for your own actions in accordance with EU policies or EU regulation. So the assessment that you do is going to hopefully identify any gaps that exist in your system. And if you've got gaps, then that's the time to plug the hole and address it. That gap analysis and the assessment, I think they're the most important tool that we have right now, because honestly, you don't know what you don't know about the risks that you have until you dive in and take a look at it. So that's the next slide. I think this is important to talk about the data protections that are possible under the GDPR and just possible in general. And I wanted to say pseudonymization again, if I could. But the types of protections that are available for personal data that are mentioned in the GDPR are encryption. That's always a good one. If data is encrypted, I think that the idea is that the rights and freedoms of the data subject is less likely to be harmed by a breach of a data system. And that might keep you from having a breach reporting obligation. Then the data pseudonymization, where they separate out the data points so that they have to be knitted back together in order to identify an individual. That's something that I have seen more recently happening in some of our clients. The disaster recovery plan, always a good idea. You might call it a business continuity plan, probably already have one. Something that would enable you to get back up and running so that you can make decisions and also be responsible to your data subjects. Breach monitoring solution. I wanted to mention that because I think probably all of us have something like that for our systems, but it's surprising how many people, when you ask them, say, we don't ever look at it. So something is monitoring what's happening to your system, but nobody's watching the store. So that's certainly something to think about. And then the data breach response plan. The reason I mention that one is it is mentioned in the GDPR, and it is also something that I think you could have. And if you don't test it out and do a dry run, it's probably not worth having because you don't want the first time for you to work through that particular plan to be when you've got an issue. Most often, I think some of our clients who are outward facing would say, you know, I don't know when I should contact the media. I don't know who should contact the media. How am I going to talk to the board of directors? All of those kinds of things should and could and should be addressed in the data breach response plan. And that's also something that once you have it in place, it helps you put together the compliance piece that you have an obligation to furnish if you're a data controller. Okay, next slide, please. All right, if everything goes wrong for us under the GDPR, what happens? For the EU, there are Data Protection Authority or DPA actions that can be brought. There's a private right of action for a data subject. And then the fines that go along with the Data Protection Authority action, that's a typo, sorry you guys, it should be EUR 20 million. So it's 20 million euros or 4% of the annual revenue of the organization, whichever is higher. So it's kind of startling. And then in the US, the FTC, under that data privacy shield, they've got up to $40,000 a day for non-compliance. I can also tell you that, you know, outside the framework of the GDPR, we've got 48 states and a couple of protectorates now, DC, Puerto Rico, Guam, that have data breach notification statutes that may provide a private right of action for some of our data subjects in the US, even if they're not involved with the EU. Let's see here. Okay, I think we're to the last slide where I wanted to tie it all back to higher education to the extent that I haven't. These are the kinds of data I think you guys would have that the EU would consider. If you have a data subject from the EU, you probably need to look at this information and figure out whether or not your protections are good enough. The one that I find the most startling, I guess, is the logs of activity, because I use the library records and the door access logs, because in my library, when I went to the University of Richmond there in Virginia, we had after hours a card we could use to get in, and now that log and that record could be personal data under the GDPR. So certainly something to think about. I think if the university or one of its vendors processes any records like those that are listed in the bullet points for students traveling to the EU or being recruited from the EU, or if you have employees or contractors from the EU, then you may be covered by the GDPR. You're going to have to look at it at least. It's not a guarantee just because it's an EU resident, but certainly for a non-EU controller or processor, if you're offering goods or services, it's something to think about and look at, and just look at the risk. Again, at this point, I think your best defense is a good offense. So get started on evaluating your information governance processes and work with your IP partners to ensure that you guys have got a plan in place. It may not be the gold standard according to the GDPR, but if it meets the needs of your data subjects, I think that's a way for you to show compliance. I think that's all that I had. If anybody has any questions, I'm happy to field them.
Yeah, if you do have any questions, just be sure that you have unmuted your microphone and just speak up. And I think we've got a small enough crowd to where it should not be too problematic for folks just to jump in. And if you would, just give us your name and the institution you're with, please.
Question. This is Jamie Leahy from Center College. One of the things that I'm thinking about is if when we have applicants for coming to Center College from residents of the EU. We are a Common App school, so they would be using the Common App, but they might also be using our website. Who knows what all they're doing. Do you happen to know how the Common App structure works as perhaps a data processor or maybe their data controller? I don't know how they function in that way, but you know, how might that work with regard to these data protocols?
Well, hopefully they have thought about it, because I'm certain that they are, you know, that's a big organization doing a lot of business with, but I think that's the kind of organization that has been targeted by the GDPR, right? They're trying to, because in the past with the privacy directive, companies were able to get around the requirements sometimes by having the processing done in a non-EU member state. So they would get processing done somewhere where their privacy directive didn't touch. And so that's truly the idea behind the GDPR, is to make it a more, you know, to protect the data wherever it goes. And so I feel like, you know, it might be worth a look at the agreement, the provider agreement that you have, to see what it says about its relationship to you and what its safeguards are. Because if they have the appropriate technical safeguards in place, then the risk to the personal liberties and the rights and freedoms of the data subject should be low. And that's really what they're trying to do, is to make sure with the GDPR that the risk is low. And if there is something that goes wrong, that everybody's going to know what it is and how to take care of it. Now, the other piece I think that might be more problematic would be the right to portability and the right to erasure. So if that person has put information into a website and they're an EU subject, and they reach out to you and say, I want that to be erased, I want to fall off the grid, you know, that's something that we may need to think about. I wish I had a lot of answers. You know, it doesn't become effective until May of next year, and I think a lot of these things will be hammered out eventually. But right now, it may be enough to just start thinking about it. And you are thinking about it because you've identified 2 places where you want to see if you have enough protections in place to meet the needs of the EU people. And I think that that's a good start.
Rebecca, this is Kyle Anderson from Center College as well. We have lots of different partnerships with different schools, both in the UK and Europe and other places. Right now, I don't really know exactly when and how the UK is going to pull out of this. Do we know if they're subject to these regulations currently?
The colleges in the UK?
And the students that would be coming, because we do host students from Northern Ireland and London.
Well, the UK has said that they are going to take part in the GDPR framework. Certainly they will be taking part until they exit. And I think that the ICO there has said that they are going to, sorry, I saw a question pop up, that they're going to do right by the data in terms of the EU. I don't know that they will adopt the GDPR, but I think they're going to try and reach those standards.
Thank you.
Let me also mention to all of our participants that Zoom has a chat feature as well. So if you prefer to utilize that as opposed to chiming in verbally.
Yeah, I just saw chat come up down there.
You can access the chat feature by hovering over the Zoom window. There will be a number of icons that will pop up on the bottom of the screen or someplace on the screen. On the right side is a More button, and if you click on that, you'll have a drop-down window that will include a chat option. So feel free to utilize that if you'd like.
Okay. Do you want me to read out the one that I see, or?
Sure, sure.
Okay. So just to be clear, offering admission to students from the EU qualifies us as a purveyor of goods and services. I wish I could say that affirmatively. I think it's certainly a possibility, but I don't know that I would say that. I think we'd have to look at what the definition of services evolves to be. I'm sorry, I know that's a kind of a weasel answer, but until it really comes out and gets laid out, I'm not sure I would have a better one.
Well, let me ask you about, this is Jamie Leahy from Center College. Let me ask you about, you talk about data of employees, and we have a handful of employees in the EU, and we already have, I think, some pretty tight controls on our information that we have for them. But you know, it sounds like we're going to have to put in place higher levels of protection for data on them in particular, to make sure we're in full compliance with this regulation, particularly for our EU-based employees.
I would, yes. I guess the data, it really doesn't matter where it's processed, but I would assume that they're there. So, yes, I think we will.
And you know, that sort of thing in the hands of our accountants, and you know, to what extent does you know, ought we be concerned if any of that comes over here into our finance office, for example, or in the office of our global citizenship director or something like that, as the supervisor of these employees?
I'm sorry?
I'm thinking about, you know, do we need to build a firewall to make sure the data on our EU-based employees basically stays in the EU, and make sure we don't have records coming over here
For processing?
in the normal course of our business?
I think that's one way to do it, yes. I think you can see how that would pan out for you. Yeah, I can see how that would work. Because again, you're trying to make sure you just have the appropriate technical safeguards. And so the transfer coming from them to us, I think we'll have to start looking at what the Privacy Shield says and how we can certify under the Privacy Shield. I mean, if it's an expensive process, then maybe the firewall is the right way to go. If it is something that we can certify, kind of like we would do a business agreement with someone who's processing our medical data, if we could put that in place, then maybe that's what makes more sense, is to self-certify under the Privacy Shield.
Do you anticipate that American-based colleges like this group of colleges here might try to certify under the Privacy Shield in those cases?
I think it would depend on how much data you have. If you have a lot of data, or if you're doing a lot of research analysis, I think to be safe, I would want to try and make sure that I had self-certified. But again, it's going to be, what's the question of cost? And does it make more sense to just try and put in place a moratorium on transfer?
Do you think there might be some opportunity for the members of ACS to try to develop those kinds of protections as a group, such that rather than having 16 bills, they'd have one bill that could be allocated 16 different ways so as to save on some of the expense?
For the Privacy Shield certification, I could certainly see that you would want to, you know, develop a coalition and see if you can come up with a standard set of policies and procedures that would meet the EU GDPR and also meet your needs. Because although it is kind of the gold standard and it is a bit of a pain, you know, I don't know, I guess I've just been doing compliance for so long, it doesn't really bother me to try and reach that standard. There are times when I have clients who have some financial information, but they don't qualify as a financial institution, and I still want them to reach for the GLB standards, the Graham-Leach-Bliley standards, because it's the gold standard. If we can get close, then maybe we're always going to be protected. But I do admit that I'm incredibly risk averse. So I think there's room out there for others who are less risk averse than me to come up with creative solutions. I think that's the one thing that most people who have looked at the GDPR have said, is that there's not going to be any one size fits all, because I think most organizations keep thinking maybe some IT provider or some software group will come up with a one-stop shop for all of us. And that's the one thing about these kinds of programs. They have to be tailored to what you all need in your different environments, because it's a combination of policy and hardware and software and procedures and implementation. It's a process that's going to be peculiar to your own environment. And that's, I think, part of the fun for somebody like me, and probably part of the the woe for most folks, is that it's hard to get your arms around a unifying standard. I mean, we've got the GDPR, that's a unifying standard, but a unifying way to address it.
We have time for one more question if there are any more.
And I'm happy to.
Rebecca, can you hear me?
Yes.
This is Owen Williams from ACS. Just following up on Jim's question, which I'm glad he asked, is there a process that we should start to contemplate as to how best to pursue something as a group?
I would think we just need to look at the Privacy Shield and see what the requirements are to see if you can even certify as a group. I mean, I'm thinking probably you can, but that's something we need to take a closer look at.
I mean, is that something that you would do for us, or what are your thoughts on that?
Yes, I can do that.
I mean, if you wouldn't mind, I think that would be a great service to the group.
Okay. I will take a look at that issue. And I also will, for our folks who chatted in, I will look at whether or not there's any carve out for a U.S. college as a purveyor of a service. I'll take a look at that as well, and maybe we can put that somewhere where the folks who are on here can look at it.
Well, thank you very much for your presentation, and thank you for offering to follow up. Appreciate it very much.
I appreciate having the opportunity to speak.
Thanks, Rebecca. If any of you have any additional questions for Rebecca, her email address is on the front end of this presentation, or you can get it off our website at steptoe-johnson.com. And matter of fact, Rebecca, you might just give everybody your email address verbally.
Sure. It's
Rebecca.batesmano.
Yes, rebecca.batesmano@steptoe-johnson.com. And I'm happy to take questions offline.
So feel free to touch base with Rebecca about those questions as they come up. If you have registered for the seminar, we should have an email address where we can send you some follow-up information later on. Thanks, Rebecca.
Thank you.
Well, that takes us now to the free speech part of the presentation. And I am delighted to have the opportunity to talk just a little bit about this. This is a hot topic, if there ever was one, in higher ed. And what I want to try to do is focus specifically on the free speech and academic freedom problems that crop up in the context of private institutions. Our friends at the public institutions have a different set of issues. They are subject to the First Amendment day in and day out, and that creates a whole bunch of issues for them that we don't have to be quite so concerned about. But we'll talk just a little bit about that along the way. In fact, we'll start by talking a bit about the First Amendment. Even though it's not directly applicable to private institutions, there are some First Amendment aspects to this that we need to address. There are countless court cases interpreting the First Amendment specifically and the free speech rights in particular. There's no way we could touch on all of those, but we'll hit on just a handful of them as they do shed some light on some issues on campuses. We'll take a look at some issues that are specific to private institutions, some issues that are important to campus leaders, and talk about how all of this can help us create more inclusive campuses, which I think most of our institutions would view as a plus. Well, when you look at the First Amendment, it's a pretty short and sweet statement of issues that I'm sure are familiar to many of you. That's it. It's not a lengthy amendment to the Constitution, but there's some aspects of it that I want to highlight for you. And let me start by noting that the first word there is what sort of gets us off the hook here. The First Amendment prohibits Congress from making any law respecting, among other things, freedom of speech. Now that's important because that means unless you are a governmental actor, it's been interpreted over the years to not just mean Congress, but any governmental agency can't make rules that impinge upon freedom of speech. And if you look at the First Amendment just a little more closely, you'll see there are actually five different privileges, freedoms that are established there that are protected by the First Amendment. You can see the freedom of religion, freedom of speech, freedom of the press, freedom to assemble, and the freedom to petition the government for the redress of your grievances. And for those of you who like to look at it a little different way, there's a chart that sort of emphasizes those five freedoms. However, if you look at some of the key cases that have been decided as they deal with free speech in the context of higher education, you learn some interesting concepts that elaborate on that fairly simple and reasonably straightforward First Amendment. First, there's a recognition by the U.S. Supreme Court that the classroom is, in effect, a marketplace of ideas. So the court system has recognized that college campuses are somewhat unique in that there are few places where ideas should be given the opportunity to flourish as much as they do on a college campus. Beyond that, and I think this is a real important case for campus leaders, the Supreme Court has talked about when something really does become a threat. And it has said that despite however hateful or disgusting or ugly, vile, name the adjective, some speech may be, it can only be considered a threat when those statements communicate a serious expression of intent to commit an act of unlawful violence against a particular individual or group. So there's a lot you can say and there's a lot you can do that doesn't quite rise to the threat of intent to commit unlawful violence against a person or a group on campus, and it's going to be protected by free speech. Last but not least, I would point out that in 1999, in the Davis versus Monroe County Board of Education case, the Supreme Court said harassing statements in an educational context are prohibited only if they are so severe, pervasive, and objectively offensive that it undermines the victim's educational experience and that victims are effectively denied equal access to educational programs and resources. So what are some of the takeaways from the case law? Well, uncomfortable or offensive speech is protected under the First Amendment. A commitment to free speech is really only meaningful when it's supported in the face of pressure. And what we've seen is that claims for suppression of speech are often based in those environments where somebody is taking an I'm right and you're wrong position. Now, having said all that about the First Amendment, I would readily point out that because private institutions are not governmental actors, First Amendment issues aren't necessarily going to be dictating what you have to do on your campus. They may, however, directly impact on your campus, because I'm not familiar with, I haven't been on all 16 campuses yet, but I've been on a majority of them. And almost without fail, there are public rights of way within or immediately adjacent to your campus where free speech concepts do have some applicability. So for those of you who think, well, we're a private institution, we don't have to worry about this First Amendment stuff because it's our property and we can do what we want to on it, that is basically true with respect to your property. But keep in mind those streets and roads that sometimes bisect your property or are immediately adjacent to your property may be areas where you have to be concerned with what can and can't be done by folks who are marching down that street. In addition, I think all private institutions, and heaven knows the 16 members of ACS, are all the beneficiaries of a real strong tradition of campus debate that's promoted by a variety of different sources. Foremost among them, I would suggest to you, is the faculty handbook. The faculty handbook, in my judgment, is most every college's most consequential contract, because in many respects it goes to the core of the institution. How are faculty members going to interact among themselves and with the institution as a whole? And almost invariably, there are concepts written into the faculty handbook that deal with what exactly the institution will permit their faculty members to do as a matter of academic freedom. So when you think about free speech and academic freedom on campus, one of the best places to start trying to assess what the rules are at your institution is going to be faculty handbook. Beyond that, as you'll see in the next subheading there, administrative policies are another major source of what can and can't happen on your property. That can run the gamut from real estate facility use policies to where on campus you will permit student organizations to congregate. All those types of issues are ones that are addressed in administrative policies, and they can have a big impact on the kinds of free speech that you do or don't permit on your campus. At the University of Virginia, for instance, one of their policies prohibited the use of open flames on campus. Now, the folks who were there that Saturday night back, or Friday night back in August, weren't aware they had a policy in place that could have limited a lot of the activity on campus, but they just didn't enforce it. Nevertheless, the point is, those administrative policies that you have in place can have a lot to do with what individuals on your campus can and can't do under free speech concepts. And last, I would point out the whole notion of the heckler's veto. The heckler's veto is a situation where someone comes in and heckles a speaker to the point at which the speaker's ability to deliver his or her thoughts is shut down. And the heckler's veto has been roundly criticized as a means by which free speech on campus is effectively prohibited. So having in place policies that identify when hecklers can heckle and when they can't, or the extent to which they can or can't heckle somebody is important on a private institution, because that will in large measure determine what ability you have to limit that kind of activity when it starts to occur. And then the last thing I would say is that I think private institutions are particularly significant places in the broad scheme of debate that our country has cherished for so long. I would readily admit that even on private institution campuses, you're subject to some political limits. For instance, if your largest donor has donated enough money to have a landmark building named in his or her honor, and all of a sudden somebody wants to come out and give a speech on something that is just abhorrent to that donor who is still living, you probably have a political problem on your hands. I recognize that. But by and large, there are fewer political restrictions on a private institution's debate than what you're going to find on public institution campuses. And that can be a real selling point, I think, for private institutions like the ACS members. What I want to do now is, recognizing that this is a really busy slide and the next 2 or 3 are as well, I thought it might be worthwhile to take a look at the AAUP statements on academic freedom. These are, as you'll see from the footnote there, from the AAUP's website. But if your particular institution doesn't have language exactly like this in its faculty handbook, at least in some respects, you probably have something very close to it. And so when you look at academic freedom, you can see by these statements from AAUP that it's kind of a core issue as far as AAUP is concerned, and has been for decades. This is worth reading in just a little detail. Protecting academic freedom is the AAUP's core mission. Academic freedom is the indispensable requisite for unfettered teaching and research in institutions of higher education. That is a strong statement. And it is indicative of what a deeply held value academic freedom has been throughout our country. And AUP deserves a lot of the credit for having established this back in the 40s and having protected it over the decades since. So I think understanding the enormous significance that AAUP attaches to academic freedom is important. And it applies in several different contexts. One is in research. Teachers are entitled to full freedom in research and the publication of the results, subject to adequate performance of their other academic duties. But research for pecuniary return should be based on an understanding with the authorities of the institution. So you've got a lot of freedom to do your research. If you're getting paid for it, there needs to be an institutional policy about that. Similarly, the AAUP has a statement on academic freedom in the classroom. And this is something that sometimes gets twisted around in the debate on campus about the scope of what it is that faculty members are entitled to do. AAUP says teachers are entitled to freedom in the classroom in discussing their subject, but they should be careful not to introduce into their teaching controversial matter which has no relation to the subject. Limitations of academic freedom because of religious or other aims of the institution should be clearly stated in writing at the time of the appointment. So, contrary to what I have heard voiced in some settings, there are limits on academic freedom in the classroom. as a general proposition. And obviously you have to look at your particular faculty handbook to see exactly what those limits are, but most of them will have language very comparable to what you see here. Beyond the limits that are the specific limits in research in the classroom area, AAUP also imposes some limits on academic freedom as a general proposition that I think are important. And all of this goes to what faculty members can and can't say on campus and in the community. College and university teachers are citizens, members of a learning profession, and officers of an educational institution. When they speak or write as citizens, they should be free from institutional censorship or discipline. But their special position in the community imposes special obligations. As scholars and educational officers, they should remember that that the public may judge their profession and their institution by their utterances. Hence, they should at all times be accurate and should exercise appropriate restraint, should show respect for the opinions of others, and should make every effort to indicate they're not speaking for the institution. So there are limits on what faculty members can do out in the community as well. So if you go back and you think about what academic freedom and free speech are suggesting as guidelines for campus leaders, I would offer these several factors to consider. First, how do we define the limits on academic freedom? As you've seen from what we've just talked about, not everything goes under the heading of academic freedom. There are limits that have been in place, although sometimes ignored, but have been in place since the 40s in many instances. And having an understanding with folks on campus about how exactly those limits are imposed on your particular campus is important. In addition, another significant issue for campus leaders is how do we create a campus of diverse ideas, one where the entire campus community is encouraged to participate in the give and take that is sort of the hallmark of American higher education. We want our campuses to be crucibles in which ideas are exposed to a lot of heat and refined as a consequence of a rigorous campus debate. That certainly involves the faculty, and we've talked about that in the context of the faculty handbook, but there are a lot of other players on campus that need to be involved in that debate. Certainly students should be. There are a number of staff members who need to be engaged in that discussion so that they understand what's going on campus when they see these vigorous debates breaking out, and they should celebrate that kind of rigorous debate. But if that conversation doesn't take place on campus and those institutional cultures are not accurately reflected in the policies that govern debate on campus, you can have a lot of people on campus, especially those faculty or staff members who may be relatively new to higher education, wondering what on earth is going on here. This is not the way it operated when I was working at the department store downtown, or when I was in the manufacturing office down the road before I came to work at this crazy campus, and helping new employees particularly understand what's going on there, having in place institutional policies to promote diverse ideas is important. And then beyond that, I think there's a role for campus leaders to play in helping our communities and our country, for that matter, understand what's going on campus. All of our institutions have a lot of friends, I hope. alumni and donors are ones that come to mind especially. But there are also folks in your home communities. There are folks across your respective states and all across our country who sometimes wonder what is going on and why is this sort of debate important. Well, it is vitally important for campus leaders to help all of those stakeholders understand that one of the reasons why college campuses exist is to have as much vibrant, robust debate as possible so that new ideas can emerge from old ideas, and so that our country can be the beneficiary of that whole vigorous debate process. And sometimes that's really important just from the standpoint of developing the political support necessary to sustain these institutions. You've all probably seen some of the recent polling data that reflects that there are many folks in influential positions around our country who think college campuses are not very effective. They're not good investments of money. They're helping to create a bunch of liberal crazies to the exclusion of other points of view, especially more conservative points of view. And being sensitive to those concerns is important in terms of maintaining a good political environment for our institutions and helping to foster an environment on campus where robust debate can continue to occur. And then I think campus leaders also need to help our country understand why our faculty members at private institutions are critically important to our nation. We have a lot of outstanding faculty members who are doing great research, who are helping to expand the knowledge base, and I often think our friends in the broader community fail to fully appreciate that. That's important for us to be able to maintain that environment of a robust debate on campus. So here's one way of thinking about those competing interests. The faculty have a set of issues, folks on campus have a set of issues, friends and community leaders have a separate set of issues, and trying to help these different groups all understand that right in the middle of all of this, there's a very sweet spot where our institutions can really start to address issues that are important to all of those groups and make progress for them as an institution. So now the question becomes, how can campus leaders help to facilitate effective speech on campus? It's not going to be totally free all the time. As we've seen, there are limits to academic freedom and otherwise. But here are some ideas that I hope you might be able to utilize. First, take a look at the faculty handbook. And I recognize full well that touching the faculty handbook can sometimes be viewed as being the third rail of higher education, right? Getting involved with the faculty handbook is fraught with a lot of potential problems. But the question that I'm trying to get you to ponder here is, are the values reflected in that faculty handbook a fair reflection of the values of the institution? If they are, great. If they're not, then there needs to be an effort with the faculty, certainly, to modify that handbook to more nearly reflect what the institutional values are when it comes to academic freedom and free speech generally on campus. As I said a few minutes ago, there are very few, if any, contracts that are any more important to an institution than the faculty handbook. And it merits that kind of scrutiny from time to time just to make sure it's consistent with what the institution's doing. Then beyond that, take a look at your institutional policies to see if they appropriately promote the effective exchange of ideas. That can manifest itself in a lot of different ways. We talked about the University of Virginia's policy about no open flames on campus. I doubt when they were drafting that policy, they were thinking about a bunch of white supremacists coming to campus with tiki torches. But nonetheless, those policies have a lot to do with how you effectively promote free speech on campus. For instance, does your institutional policy handbook contain a policy that only permits speaker invitations to be extended by the institution? Or does every student group of 3 or fewer members have the ability to invite people to campus? And all of a sudden, administration's contending with some nut who's got no following, but is basically inciting a riot that nobody knew about. So do you have an institutional use policy that gives the institution some ability to be aware of and to limit appropriately speakers? Do you have a policy that limits the heckler's veto? Do you have a policy that identifies the appropriate public safety response when there is an incident on campus? And there are a bunch of other policies that we could talk about at some length that could impact your opportunities for free speech on campus, effective speech on campus, and you need to take a look at those in advance. And then as I mentioned a moment ago, it's important to visit with community stakeholders about why it is important for your institution to have the free exchange of controversial ideas on campus. And I think if you do all 3 of these things, you will have the faculty, the broader campus, and the friends of the institution coming to some understanding that, you know, that college isn't crazy. In fact, they're doing the public a lot of good by engaging folks in these sorts of critical debates about the future of our country or any one of a number of different topics these days and times. So with that said, let me throw the floor open for questions, because this is a bit of an abstract topic, and it's one where sometimes kicking it around can be helpful in terms of developing a broader understanding. Again, let me remind you, we have the chat feature that is available if you'd like to use it, or you can just speak up and everyone should be able to hear, and if you've got your video camera on, see you.
Jim, I've got a question. This is Jamie Leahy at Center College. What do you see in terms of best practice, or what do you see as effective that colleges are doing to try to guide students or police students in particular in their speech and expressive behaviors, particularly in social media?
Social media is, I'm sorry?
What kind of policies are people coming up with that you see that are effective?
Not very many, to be honest with you. The social media area, of course, is one that's reasonably new, but I'm not sure that I've seen any institution develop one that works especially well just yet. There are a number of efforts that are being made. I've seen those, but in terms of which ones do I think have a silver bullet, I can't point to one, unfortunately, Jamie. Many of them are making these kinds of policies subject to the student code violation process, and you would hope as a result of some students being disciplined in that setting that there will begin to be some understanding of what works and what doesn't work well. But frankly, I haven't seen one that I would commend to you as being especially good at this point. It's a challenging area. Now, some of the good news is some of the worst ones, like Yik Yak, have bitten the dust. And you hope some of those things never see the light of day again, and because they certainly complicate the lives of our friends in student affairs who are trying to deal with that. But I guess the one thing that I have seen some institutions do that I would recommend is monitor the key social media sites to see what students are seeing, and then try to be as proactive as you can in dealing with it. Because sometimes if you don't monitor it and get ahead of it, it can be so far ahead of the administration's reaction to it that it's virtually impossible to contend with. So I guess the one thing I have seen people doing, not so much a policy, but just as a routine, is trying to have an active presence on social media with somebody on the student affairs staff monitoring what's going on out there that may impact your campus. Any others? Well, let me just conclude then by saying that we're glad to have the chance to visit with you. Our contact info is on the screen there. Feel free to let Rebecca or me know if there's any follow-up that would be helpful to you, and we'll try to get you a response. I want to, again, thank you for spending a little time with us this afternoon. Hopefully it has been an exercise where you feel more familiar with some of the challenges in these two areas and more prepared to deal with them on a going forward basis. If we can help you in any fashion, don't hesitate to let Rebecca or me know. With that said, we'll conclude the video conference, and we look forward to being back in touch with you in the spring with a new version of the Legal Topics seminar. In the meantime, if you have questions or suggestions, rather, of topics that we should address come the spring, please let us know. Have a good day.
Thank you. Thank you.
Thank you, Jim. Thank you, Rebecca.
You're welcome. Goodbye.